The Honorable presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Good morning, everyone, and welcome to the virtual WebEx Court of Appeals. Your panel this morning includes me, Judge Donna Stroud, and I would normally say to my right and my left, and I get really confused here. But anyway, the other members of our panel this morning, we have Judge Don Tyson and Judge Cody Hampson. And we have one case for argument today, which is State versus Marquez v. Graves. And it looks like everyone is ready to proceed. So we have the timer automatically set, I believe, for 5 minutes of rebuttal. If you wish to change that, let us know now, and Mr. Horn can change it. If that's okay with you, then that is what it is normally set with. So, Mr. Orsman, is that?
Yes, 5 minutes is.
Okay, very good.
Thank you. Perfect.
All right, then you may proceed.
Good morning. May it please the court. I'm Assistant Appellate Defender Wyatt Orsman, and I represent Mr. Graves in this case. On the second morning of Mr. Graves' murder trial, the DA walked into the courtroom and announced previously undisclosed items that were held at the prison where Mr. Graves and the victim were inmates. Some of the items were clothes that the DA believed Mr. Graves was wearing about 2 hours before he got into a fight with the victim. Excuse me, a fight he got into about 2 hours before the victim was killed. And the clothes had stains on them that looked like blood. The DA requested a mistrial so that the clothes could be tested. No matter what the DNA test results showed, the DA argued it justified a mistrial. If the stains were Mr. Graves' blood, as the DA hoped, then the state would need that evidence at a second trial to corroborate potential witness testimony that prior altercation had in fact occurred. The DA also argued, on the flip side, that the evidence could end up being exculpatory if the stains on the clothes ended up not being Mr. Graves' blood. Neither of the state's reasons constitute a manifest necessity justifying a mistrial. A mistrial cannot be used to allow the state to strengthen its case against the defendant, nor can the state's beneficent motives be used to override a defendant's valued right to continue with his trial with the jury already impaneled. Because no manifest necessity existed in this case to terminate Mr. Graves' first trial, the second trial court erred by denying his motion to dismiss at the beginning of his second trial. This court should reverse that decision. When the purpose of a mistrial is to give the prosecution an opportunity to strengthen its case or buttress its argument or develop more evidence against a defendant, the reviewing court applies the strictest scrutiny to the trial court's decision to declare a mistrial. And under this standard, the prosecution bears a heavy burden of demonstrating that the mistrial was compelled by manifest necessity. The state has not carried that burden here. At trial, the state offered two reasons for a mistrial. First, the evidence was critical to its case against Mr. Graves, and second, the evidence could end up being exculpatory for Mr. Graves. Neither of these reasons withstand the slightest scrutiny on appeal. The evidence was critical, the DA claims, because if the stains were Mr. Graves' blood, they would corroborate testimony that Mr. Graves was involved in the prior altercation. And according to the DA, a mistrial was warranted because the public's interest in a fair trial required the jury to hear all available evidence. Both the United States Supreme Court in Downham and our Supreme Court in Burkhead have come to the opposite conclusion. Society definitely has an interest in a fair trial concluding in just results, but society does not have an interest in maximal prosecutions.
Mr. Orsborn, Mr. Orsborn, if I can jump in and kind of take a step back, because would you help talk me through kind of our standard of review here? Because one of the interesting things about these cases is, on one hand, we're kind of looking back at the original grant of the mistrial, which we would generally look at through the lens of an abuse of discretion. Did the judge make a rational decision here? But on the other hand, we're also, I think, at the heart of it, reviewing whether or not the second trial judge should have, Judge Blunt should have dismissed this case as a matter of law on double jeopardy grounds. So we kind of help reconcile our standards of review of those sort of different issues.
Sure. The standard of review for the motion to dismiss is similar to any other motion to dismiss. It's, you know, it's a question of law. It's reviewed de novo. I think in this, you know, in the double jeopardy context, what you're really doing is you're reaching through that decision, the motion to dismiss decision, and reviewing the first trial court's decision granting the mistrial. And there, the United States Supreme Court has, and plenty of other courts have talked about, there's sort of a sliding scale of scrutiny, right? On the most deferential side, we have the abuse of discretion standard, you know, for example, when the jury is deadlocked. But on the opposite side of the continuum, the strictest scrutiny applies, when the decision to grant the mistrial was to afford the state an opportunity to strengthen its case against the defendant. You know, whether that be the purpose for the mistrial or if it's just the result, you know, I don't think it matters here, but the standard of review here is the strictest scrutiny. And in my memo of additional authorities, I cite several cases, particularly from you know, federal circuits, that explain that, look, when you're dealing with a decision to grant a mistrial to help out the prosecution, you know, the decision of whether there's manifest necessity, that's a question of law. Like whether you call it the strictness scrutiny to the application of the trial court's discretion, or you want to call it just straight up a question of law, which I think is, you know, correct. You know, at least the first, third, and sixth circuits view it that way. That it's really a question of law. Is there manifest necessity here?
Mr. On page 11 of the state's brief, they cite State versus Schoaf in the first full paragraph, and I'll read it. The decision to declare a mistrial will not be disturbed unless it's manifestly unsupported by reason or so arbitrary that it could not have been the product of a reasoned decision. That's clearly citing state authority, going back to Judge Hampson's question on our standard review. And if it is abuse of discretion, you would agree it would be deferential to the judge, correct?
No, I don't. Arizona v. Washington is very clear. It talks about the trial court's decision as the trial court has discretion in proceeding through and considering its options and parsing the facts and looking at what happened. But the reviewing court applies the strictest scrutiny to that discretion. The strictest scrutiny. That is not deferential. Not according to the United States Supreme Court.
Well, now, if it was truly to give the benefit of the fair trial and to possibly exonerate your client, we would have to accept your characterization that the evidence was only to help the state and not to help determine whether or not your client was guilty or not. Isn't that correct?
No, I don't believe that's correct. I think it's important to note that if you look in the trial court's order, it made no findings of fact or conclusions of law that the evidence could be exculpatory. So that was not a basis of the trial court's decision to grant the mistrial. So you're not taking my characterization, you're taking the trial court's characterization of what happened.
So the testing of the clothing could not possibly exonerate your client?
No, I don't think it could. You know, this is a point that I was going to bring up later, but I think it's, you know, let's jump into it now. Who was the one person in the best position to know whether those clothes were Mr. Gray's clothes? Who was in the best position to know whether that was Mr. Gray's blood on those clothes? He was sitting right there at the defense table. It was Mr. Gray's. He did not want testing. He wanted to pursue, to continue with his trial with the jury already impaneled. Right? The argument that the evidence could exonerate him it's not supported by the trial court's order. It's not supported by the record, right? Just because the blood on, let me say it this way, if the evidence turned out to be Mr. Gray's blood, that would certainly be inculpatory, right? It would certainly be inculpatory because it would show that he was in fact in the prior altercation. But the inverse would not be true, right? If it turned out not to be his blood, that wouldn't disprove that he was involved in the prior altercation. It would just mean he didn't bleed on the clothes. Right? There's based on the record we have, the evidence wasn't going to exonerate him, and he was more than happy to forego testing to continue with the jury that he already had. Turning back to my argument, the state's not entitled to a maximal prosecution, right? Once the jury's impaneled, the state isn't entitled to a do-over simply because it learns it could have marshaled more evidence against the defendant. Yeah, as the trial court noted, and as the DA conceded, even in the best case scenario for the state, it only corroborated one single witness's testimony about an uncontroversial fact, that Mr. Grays and the victim, Mr. Floyd, had gotten into an argument about 2 hours before the victim was killed. Under the state
and Mr. Osborne, is it correct? My recollection is that was corroboration was the only reason the state wanted this evidence admitted. This was not being introduced as sort of substantive evidence of a crime. This was being introduced only, or presumably would have been introduced only for corroborative purposes. Is that correct on this record?
That's correct. If you look at page 202 in the record, the trial court, Judge Grant, asked the DA just straight on, is there any other reason other than corroboration? And she says no. She says, I agree. There's no other use for this evidence. It is merely corroborative.
And approaching it from the other side, kind of going back to Judge Tyson's questions, you know, to the extent this evidence could have been potentially helpful or exculpatory to the defense, you know, would you characterize this more as sort of young blood evidence in that it could be beneficial, it could be exculpatory, or is this really Brady evidence where it is exculpatory, sort of demanding disclosure, versus young blood, which is only if there's bad faith?
I guess I would consider it more like Brady evidence, but you know, honestly, I think that the state's argument about the evidence being exculpatory is just manufactured. right? Judge Grant, who had been a prosecutor for years, had a hard time believing that argument. I mean, it's just not supported by the record in this case that the evidence could be exculpatory. And I part of why I cited Simmons and Ruiz in my motion, or excuse me, my memorandum of additional authorities is a defendant is free to, Mr. Graves is free to waive learning of the test results in this case in order to continue with his trial, right? Just like a defendant can waive receiving Brady evidence before pleading guilty, right? It's similar to Ruiz in that case, and it's similar to Simmons, which I also cite. Mr. Graves can't be forced to forego waive one constitutional right to assert another. But that's exactly what happened here, right? The trial court overrode or violated his right to proceed with the jury that was already impaneled in order to force him to learn the results of the DNA testing that he didn't want to learn, right? The trial court forced him to waive a right that he didn't want to waive in order to learn information that he didn't want to learn, right? I mean, that's part of the core problem with the exculpatory argument by the state.
And kind of pulled you away from your argument there with this sort of exculpatory, inculpatory questioning, but I guess to get back on track, explain to me how this potentially corroborative or at best potentially exculpatory evidence fits in within our manifest necessity standard for granting the mistrial.
Sure. Part of the analysis for determining whether there's a manifest necessity is looking at the reasons that the trial court granted the mistrial. Here, the only thing that can be taken from the order is that it was the public's interest in a fair trial that the evidence be sent off for testing, and that's where I was sort of headed with my no maximal prosecution. Under Burkhead and Downham. So once the jury's impaneled, there's no right or entitlement to a do-over just because the state learns that it could have marshaled more evidence against the defendant. So the whole corroborative evidence reason or rationale for the state just fails. It's similar to the Downham case, where the Supreme Court said, look, witnesses or weaknesses in the state's case discovered after the jury's impaneled, like that's not a good enough reason. That's not a manifest necessity under the double jeopardy clause.
Is there a difference between this case where it's sort of physical evidence discovered during trial versus one where the state allows the jury to be impaneled without making sure it's got its witnesses lined up for the trial? I mean, there we said, then it's kind of on the state. You bore the risk, right, of not making sure your witnesses were in the courtroom, that kind of thing. Is there a difference between that situation and this, where it's allegedly newly discovered physical evidence?
No, I don't think there is. In your Resendez, I'm going to butcher the name, the Resendez-Merlot case. I mean, you talked about it's the state's knowledge at the time of trial, at the time the jury's impaneled. Right, we have information. Right? The trial court did hold an evidentiary hearing. It heard from the DA's executive assistant. It heard from the assistant superintendent of the prison. They met in April 2018 to make sure that the DA's office had all the evidence, and they just assumed they did, right? They stopped investigating once the superintendent said, yeah, you've got everything we have, right? So when the jury was impaneled in Mr. Gray's case, the risk was on the state, right? It assumed that it had everything when it went to trial, and the fact that it didn't, right? The state should bear the burden of that, not Mr. Gray's, right? I mean, if we're looking at burden allocation, right, the state's failure to make sure it had everything, right, it should bear that loss, not Mr. Gray's, especially when it's merely corroborative evidence of the state claims.
Let me ask you this. Had the trial proceeded and your client had been convicted and the evidence had not come in and turned out later to be exculpatory, would you now be up here pounding for a new trial on the opposite result?
You mean through some sort of ineffective assistance of counsel claim?
No, some type of Brady, that there was evidence, material evidence concerning your client that was not turned over, that was available to the state?
Well, no, if the trial court had conducted a colloquy with Mr. Grays and made sure on the record that he consented to proceeding with the trial with the evidence untested. Right? I mean, it's a 5-minute colloquy that could have prevented, the whole situation where we are now.
So if the judge had denied the state's motion for the mistrial and you proceeded and your client had been convicted, the exclusion of that evidence would not present you a basis to come up and challenge a conviction.
I don't see how it could. I mean, it was their strategic. It would have been a strategic decision by Mr. Grays and defense counsel, like in consultation with defense counsel, about what to do. I don't know how he could raise, any sort of meritorious argument on direct appeal. Right? I mean, the evidence was, he was right there in the courtroom with everybody else. He knew what was going on. I don't think he can later claim that he was prejudiced by the fact that the evidence wasn't tested.
Thank you.
I think a couple of other points that I want to make is it ties in with the exculpation argument that the state makes. The United States Supreme Court in Jorn was clear that there's no exception to the manifest necessity rule when the trial court orders a mistrial believing it's in the defendant's benefit. Right? The trial court doesn't get to patronize the defendant, and neither does the state. Right? Mr. Graves gets to decide what's in his best interest, not the trial court, not the state. And I think going back to the DA's argument about her ethical obligations, right? Her ethical obligations didn't require her to do anything more than to notify the defense of the existence of the evidence. That was it. It didn't require her to become Mr. Gray's self-appointed guardian ad litem, not over his objection. He gets to decide. Right? United States Supreme Court decisions are clear. He gets to decide what's in his best interest. He gets to decide if he wants to go on with a jury already impaneled. And with the time I have left, I'd like to talk about the viable alternatives that the trial court had. We talked about that a little bit. And I think it's important to remember why we're talking about, or why the courts look at whether they're viable alternatives. That shows that the state, or excuse me, the public's interest in a fair trial and the public's interest in just results can still be accomplished without violating the defendant's valued right to proceed to judgment with the jury already impaneled, right? As the Supreme Court said in Burkhead, could the trial court have proceeded to judgment in a fair, orderly, and lawful manner? And the answer to that question here is yes. Right? The trial court could have continued the trial with the evidence untested, right? Assuming the state tried to get it admitted and Mr. Graves objected, the state wouldn't be able to lay a proper foundation for its use, and it would be excluded under operation of our normal rules of evidence. Right? Just continue with trial. They try to admit the evidence, object, and have it excluded. The trial court could have continued the trial with explicitly or expressly excluding the evidence, right? I mean, let's remember that the state's belated disclosure of this evidence, as the DA conceded, it was a discovery violation. It would have been reasonable. It would have been fair to exclude this evidence under Section 15A-910A3. Was the court required to do that? No, but he could have. And here's where the waiver colloquy could have come in. Exclude the evidence, continue with trial, and make sure that Mr. Graves knew that he was consenting to that strategy. The trial court could have ordered a continuance.
Mr. Orsman, I just want to point out you're into your 5 minutes. So.
Okay, let me briefly wrap up then. The trial court could have ordered a continuance, right? Send the evidence off for testing, and then hold an evidentiary hearing on whether the evidence should be admitted, right? That based on the chain of custody problems that the trial court already knew about, right? That kind of hearing would have forecasted exactly what ended up happening at Mr. Gray's second trial. What happened? There were so many missing links in the chain of custody. There were so many problems that evidence that the state didn't even bother to try to get the evidence admitted, right? They desperately asked for a mistrial in Mr. Gray's first trial, and then they didn't even try to get it admitted at a second trial because of problems that the trial court already knew about before he declared a mistrial. And then briefly, let me just conclude by saying, there's nothing in the trial court's record, or excuse me, in the trial court's order or in the record more broadly that shows that the trial court actually considered any of those options or any analysis of why they were unworkable or unfeasible or unreasonable. There's no explanation about why exclusion wouldn't be fair. No explanation about why a colloquy wouldn't have prevented a later claim of prejudice. No explanation of why a continuance wouldn't have clarified the admissibility of the evidence. Right? Without any of that analysis, there's just the trial court's decision to declare the mistrial just isn't supported. Yeah, as the Supreme Court said in Burkhead, the trial court could have proceeded to judgment in a fair and orderly manner in this case. There was no manifest necessity compelling a mistrial.
Your rebuttal time is down to 2 minutes and 32 seconds, so you might want to keep some.
And the trial court, the second trial court should have dismissed the case when it was called a second time. This court should reverse. Thank you.
All right, for the state.
Thank you, Judge Stroud. Good morning, Your Honors. May it please the court, my name is Kristen Euchre. I'm an Assistant Attorney General with the Department of Justice, and I represent the state in this matter. This is a murder case where 3 bags of evidence, including bloody clothes with the defendants and the victims' names on the bags, were located early in the trial with no evidence of bad faith. Under these narrow circumstances, the trial court's decision to grant a mistrial was careful, thorough, and reasoned. It was not arbitrary, and nor was it an abuse of the trial court's discretion. Because the mistrial was not an abuse of discretion, it was not improper. Therefore, under de novo review of the double jeopardy motion, no double jeopardy violation occurred, and the second trial court did not err by denying the motion to dismiss on those grounds. Judge Hampson, you're right. An interesting aspect of this case really is this interplay between the two different standards of review. You have, on the one hand, the de novo aspect of double jeopardy violations in general, and then you also have the abuse of discretion standard for the mistrial determination. And what is, I think, overlooked in defendant's brief is the fact that not every double jeopardy violation includes a mistrial. Not every double jeopardy claim includes an issue of the mistrial. It could be a double punishment situation. It could be any sort of other discovery violation, anything like that. So I guess what I'm trying to say is that even though in this instance, the mistrial determination is pretty much outcome determinative, it doesn't collapse those standards of review into de novo review of the mistrial. The mistrial itself is still reviewed for abuse of discretion. That's what our Supreme Court said in State v. Schaaf. State v. Schaaf was decided after Arizona v. Washington, the United States Supreme Court case that defendant was mentioning. And Arizona v. Washington itself doesn't even support defendant's argument here about the standard of review. In Arizona v. Washington, the U.S. Supreme Court said that it accords the highest degree of respect to the trial judge's evaluation of the incident's fairness on the trial proceeding. And it also points out that even though some trial judges might handle that particular impropriety in another way, such as by giving the jury some sort of cautionary instruction, thus, quote, in a strict literal sense, the mistrial was not necessary, is still within the trial court's sound discretion to declare a mistrial. And the U.S.
If I could ask a question, and this is one from the defendant's reply brief that I thought was a good question that was raised. And the defendant in the reply brief noted that the state doesn't mention Resendez-Merlos in its brief or explain how it's not controlling on this issue, and particularly with the standard of review. So if you could address that, how do we distinguish Resendez-Merlos?
Sure. Thank you, Your Honor. Resendez-Merlos is not controlling in this instance. First of all, it does recognize sorry, I'm trying to find the standard of review there. So I think that what is missing from Resendez-Merlos is that distinction that I just explained, that the mistrial determination is reviewed for abuse of discretion, and then the double jeopardy violation is reviewed de novo. To the extent that Resendez-Merlos conflicts with Schaaf, it isn't controlling of the situation. And more importantly, Resendez-Merlos is not on all fours factually with this scenario. To Judge Hampson's point, it is different because the state was not taking any sort of risk by impaneling this jury because it had no idea that this evidence was out there. In Resendez-Merlos, the prosecutor knew that his or her witness, was expected to be there an hour before the jury was impaneled and still did not show up. And the prosecutor never said, wait, Judge, my witness is supposed to be here. She's not. Can I have a few minutes to see what's going on, if she can get here, or if we maybe need to address this some other way? That was the risk that the state took by knowing that its witness was not there when she was supposed to be there. Here, the prosecutor took no such risk. She had no idea that this evidence had not been turned over. There was no reason for her to think that it was out there, and that she was taking any sort of risk by impaneling the jury, that she would have to try this case without knowing what this evidence was because she didn't know that the evidence existed.
Well, and let me just ask, so the prosecutor's got a duty, of course, to find that evidence and to have that ready. So would a ruling like this justify a mistrial? I mean, you know, this particular evidence, I think we could all agree, is certainly not as arguably as compelling as in some of the other cases, like finding the victim's body or the actual witnesses who would have to testify to the events. I mean, this is at best a piece of corroboration according to the state's argument. So, you know, it's not one of those amazing pieces of evidence. Or if you think it is, then correct me on that. But, you know, if we were to allow mistrial in this type of situation, wouldn't the state basically be able to come in and say, oh my gosh, look, we found this other thing that we think would be nice to have in our evidence. So, you know, let's do a mistrial and get that ready. Doesn't that really bring that level down quite low?
No, Your Honor. First, to go back just a tiny bit, I think that this evidence is potentially very important. As defense counsel at trial pointed out, the credibility of the state's two inmate witnesses who were the only people to testify in any way that defendant was actually the person who assaulted the victim, which resulted in his death, their credibility was paramount. And this evidence, if it did not show what they said it would show, because those two witnesses said that he wiped his blood, defendant wiped his blood on his shirt. So if defendant's blood was not on his shirt, that tends to discredit the state's witnesses. And Judge Tyson, to your point, I think that if this were in a post-conviction posture and we did have that situation, defendant would absolutely be jumping up and down and saying that that was exculpatory evidence that should have been revealed to him, and that it would have changed the outcome of the trial. Because if you can impeach those two witnesses who are the only ones who put defendant as being the one who stabbed the victim, then you can potentially get a verdict of not guilty. So I think this is important evidence, and I do not think that its only purpose was corroboration. They're kind of two sides of the same coin, which I think is what the trial court got to at the end when it said, this is on transcript page 214, this is the prosecutor speaking. She says, my witnesses say the defendant was wiping blood all over his clothes, and all the clothing is taken from the defendant's cell, and there's none of his blood on any of his clothes. How could that not be exculpatory for the defendant? Because there should be blood on some of his clothing from that earlier fight, the fight earlier in the day. And if it's somebody else's blood or the victim's blood, and then the court jumps in and says, it's not exculpatory, is it exculpatory or just being used to discredit your witness? And then the prosecutor says, I don't know, that there's maybe a difference. And the court says, maybe there's not a difference. And I think that that is the point at which the trial court understood, and maybe that the prosecutor finally articulated the argument in a way that was beyond this corroborating, because of course it would corroborate the witnesses, but I think more importantly, it would discredit the witnesses if that were not shown to be true. And
but once let's say it could potentially be exculpatory, once the DA has notified the defendant of the evidence, he's aware of that, and if he makes the decision to proceed without it, how is there? I mean, does the state get to also ask for a mistrial if they come up with something that they argue might actually help the defendant, even after they've notified the defendant that it exists and they've got an opportunity to act on that, and they decide they don't want to?
Your Honor, this is a strange situation for me to be in, where I'm kind of stepping into defense counsel's shoes and even defense counsel on appeal. But I can imagine the scenario where what they would be saying on appeal would be, or in a post-conviction, that how can defendant knowingly waive this exculpatory evidence when he doesn't know what it would show? that's always an issue with waiver of rights is, was it a knowing and intentional relinquishment, which I don't know how it can be when he has no idea what it would show.
Well, so are you saying it's not waivable? I mean, because obviously he can look at it in both scenarios. He can, he can look at it as this is his blood, this is not his blood. He can consider the consequences of both of those. And I mean, that seems to say that these are not waivable at all. That like we can't even assume that they can make that intelligent decision. We're going to have to test it and find out.
No, Your Honor, I don't think it's not waivable at all. I think that what is at issue here is the reasonableness of the mistrial court's decision in this instance, which is bound to these facts right here. And on top of that, whether it could be waived doesn't really affect the ultimate interest at issue here, which this was something I was going to bring up, which is that this mistrial was not granted for the state to get corroborating evidence. As the court said, it was granted based on the public's interest in a fair trial, which that entails following procedures and giving the public confidence in the outcome of those trials. And to say that the defendant can willfully blind himself to evidence that, months or even years down the line might become the basis of an appeal, a claim on appeal, or a claim in post-conviction relief, doesn't serve those ends of the public's interest in the fair trial. And so I don't think that this court has to decide whether it is waivable, even if that's an interesting question. That's really not. We don't have that here.
I wanted to ask you this, Ms. Euchre, what significance is it, if any, that the evidence that was the basis of the mistrial was not used in the subsequent trial?
Your Honor, I don't think it has any real significance, because I think that the important question here is whether the mistrial court was abusing its discretion, and that means what were the facts known to the mistrial court at that time. The later decision not to use the evidence merely reflected finding the answers to the questions that were unanswered at the mistrial stage. So as the prosecutor mentioned in the mistrial hearing, she was going to try to shore up the chain of custody. And she had no idea if she was going to be able to do that or not. It turned out she could not, which is why she was unable to use it in the second trial, which she had no way, and the trial court had no way of knowing that would be impossible at the time that the trial court was being asked to consider the mistrial.
Thank you.
Your Honors, to go back to the standard of review just a little bit, this court's decision in Shalo specifically did recognize that both of these standards of review are at play in reviewing these sorts of issues. That was a case this court decided in 2016, and in that case, the standard of review is explained as follows. It involved a issue about whether the indictment was facially valid. So it says, facially invalid indictments deprive the trial court of jurisdiction to enter judgment in criminal cases. This court also reviews double jeopardy issues de novo. A trial court's decision to declare a mistrial due to manifest necessity is reviewed for abuse of discretion. So this court has recognized in the past that this is the way that these issues are to be reviewed. You look at the mistrial court's decision for abuse of discretion. And while that will almost always be determinative of whether a double jeopardy violation occurred, it does not mean that then the mistrial itself is reviewed de novo. And in Shalo, that's kind of a even trickier little wrinkle, because it procedurally, that mistrial was based on the facial validity of the indictment, which that is a conclusion of law, which in and of itself is reviewable de novo. And more importantly, a misapprehension of law is itself an abuse of discretion. So that distinction didn't have a whole lot of role to play in Shalo. However, it was still there, and this court did recognize that both of those standards of review are relevant in this determination.
But isn't that sort of the point in reviewing these manifest necessity decisions, that if a trial court does have a misapprehension of what the law is regarding manifest necessity, that necessarily constitutes an abuse of discretion within the mistrial context itself?
Perhaps, Your Honor, but there is no evidence that the trial court had a misapprehension of law of what constituted a manifest necessity. It clearly, in its order, it says the court concludes as a matter of law that it's in the public's interest in a fair trial to enter an order of mistrial. The trial court was trying to declare a mistrial for the purpose of the doing justice version of a mistrial, not the physical necessity.
I want to ask you about the Shallow case. I was looking in your brief and in the memos of additional authority. Did you refer to it, either of those?
No, Your Honor, I don't believe that I did.
Would you please file a memorandum of additional authority for that?
It was cited
Yes, Your Honor.
in this brief. So
It is. It's
Yeah.
cited in
Defendant's reply brief or in the,
the defendant's original brief.
the brief.
I'm sorry, I missed that. Hold on a minute. Go ahead. I'll look for that.
It's cited on several pages of defendant's principal brief.
Okay.
Does Your Honor still want me to file a memorandum on it?
Not if it's cited by opposing counsel.
Sure.
At least I would not need it for that basis.
Yeah.
I see it now. Thank you. Can you talk a little bit about the remedy here?
Yes, Your Honor. If I suppose it depends on the nature of the court's holding, obviously. If the court finds that the mistrial determination was not an abuse of discretion, and then therefore that the denial of the motion to dismiss was not erroneous, then this court would obviously simply affirm, and the state would be free to either try Mr. Graves again for the murder offense, which he has not been convicted of yet. But if this court were to find some sort of issue, generally the remedy for a double jeopardy violation is vacating the convictions, and that is the end of the prosecution. In this instance, it could be foreseeable. I don't know if it's possible that this court would want to remand for further findings and or conclusions from the mistrial court, perhaps regarding whether it found that the evidence could be exculpatory, just to kind of clarify that if this court is not entirely certain of the factual findings there.
I have just a clarification. So he was tried on the murder charge, correct, at the second trial?
Yes, Your
And
Honor.
not convicted. So how would he be retried on that?
In that instance, the jury failed to reach a unanimous verdict. So a mistrial was declared.
I got you. Thank you.
Your Honors, going back to that issue of whether the trial court did actually think that this evidence could be exculpatory, the trial court said, the mistrial trial court said, this is on transcript page 99. He says, okay, we're going to have a hearing, Ms. Ruffin, that's defense counsel. I think out of an abundance of caution that if your man is found guilty, I think there's a possibility of a good likelihood appellate counsel is going to raise this issue. You know he is, especially if your man is found guilty and he's sentenced to life in prison. You know you and I and all of us are going to be hearing about this case for the rest of our lives. Sorry, for the rest of his life. The rest of our lives anyway, and what happened. So we need to have a hearing. And then he expresses displeasure that the evidence was not disclosed. And then he goes on to say on page 100, I mean, to me, this is a key piece of evidence, the bloody clothes. My God, what could be more telling than that? It's clear from that the trial court was very concerned that this evidence could be of an exculpatory nature. In the way that I described, that it could be used to discredit the state's main witnesses. And Your Honors, once we've determined now that manifest necessity for mistrial is reviewed for abuse of discretion, you have to determine, did the trial court here actually abuse its discretion? And the state submits no. It did not abuse its discretion for a variety of reasons. First of all, in his brief, defendant asserts that it's the state's burden somehow, which is untrue. On appeal, defendant bears the burden of showing error, including that the mistrial court abused its discretion. As the appellee,
I think what the defendant is arguing is that at the mistrial stage, it is the prosecution's burden to show the manifest necessity for a mistrial.
Sure. Which we're kind of past that now because the trial court has made its decision. And so now this court and any reviewing court is trying to determine whether that was an abuse of discretion. I don't think that the burden allocation is entirely useful in that analysis. We're looking at whether the trial court's decision was reasoned and or whether it was arbitrary. And in determining the answer to that, it's useful to look at the Fourth Circuit's Gilliam opinion, which was cited favorably in Shalo. And in Gilliam, the Fourth Circuit announced several factors that it thought would be instructive and represented kind of a distillation of the U.S. Supreme Court's jurisprudence on mistrials. And the state goes through those factors in its brief. So to run through them fairly quickly, you have the first factor is whether the ends of public justice demanded that a mistrial be granted on the peculiar facts presented. As the state has already explained, this is a murder trial where bloody clothes are in a bag with defendant's name on it, and the ends of justice demand that defendant have a fair trial. including the opportunity to have that potentially exculpatory evidence investigated, tested, what have you. And then the other factors are bearing on essentially the process that the trial court employed in order to arrive at its decision, including whether the judge acted hastily, which the judge here clearly did not act hastily. He devoted an entire day of court time to this issue. I think it was almost 4 hours of actually everyone being in court dealing with the issue. There was also some downtime that was given to allow people to prepare, including defense counsel. Another one of the factors was whether the mistrial judge expressed any concern regarding the possible double jeopardy consequences of an erroneous declaration of a mistrial, which we clearly have here, where the trial court said on page 89, I don't want to grant a mistrial, and then all of a sudden you'll find a situation where the Court of Appeals or someone says jeopardy is attached and it's too late, he can't be retried. So the trial court was clearly considering the consequences of granting this mistrial. Another one of the factors is whether the mistrial judge heard extensive argument on the appropriateness of such a measure. And I don't think that anyone has said that defendant did not have an opportunity to present evidence or make whatever arguments he wished to make at the hearing. They both sides gave pretty substantial arguments about their position on the mistrial. And then the last factor was whether the mistrial judge gave consideration to alternatives that were less drastic than granting a mistrial, which the trial court here clearly and explicitly did consider going forward with the trial and simply excluding the new evidence. No other alternatives were raised by either party, which defendant has brought up that there were other things that could be done, and perhaps there were other things that could have been done. However, there's no controlling case law that says the trial court has some duty to make a laundry list of all the alternatives it's considered. And no, the alternatives that were presented, it did consider those thoughtfully.
I have one more question. I'm sorry. So I'm thinking, so if the state gets to say, well, we have manifest necessity for a mistrial based on some evidence that's found like this, and the state, let's say, just doesn't have a huge argument for why the evidence is maybe necessary to the state's case, but says, well, theoretically, it could be helpful to the defendant. And the defendant, has got an attorney, understands the situation, clearly says, we want to proceed, we understand, we don't want it tested. That's all very clearly done. I'm just it seems like it's always going to be, if the state has evidence that's helpful to it, well, it can argue that. If the state had evidence that it's arguing is helpful to the defendant, even if the defendant says, no, I don't want that evidence. I mean, it's like, how does the state ever lose? It's like, either way, state wins, because it might theoretically help the defendant, even though the defendant said, I don't want it. Or the state argues, oh, this is really important, and it wasn't our fault that we didn't have it, and we did all we could, and it just happened to show up late, and we're sorry. How do they ever lose?
The state would lose if there was actually no way that evidence could be exculpatory. The state can't just invent a theory. That has to be supported by the other evidence in the case. And I see that my time has expired. May I briefly?
Well, I asked a question, so I'll let you finish your answer.
Thank you. So I think Baum v. Rushton actually really goes to the heart of this issue, which is, in that instance, defendant was saying, I don't care, I want to go ahead with this trial, but the Fourth Circuit said, no, you don't get to decide in this instance based on these facts. You don't get to decide. You can't just say, no, we don't want to look at that.
I'm sorry to interrupt, and I'll be brief. But in Baum, that was literally the dead body. It was literally the corpus delicti that was so surprised the defendant did not want the dead body brought into evidence.
Correct, Your Honor. That is true.
And I'm sorry, I interrupted your train of thought.
That's okay. That's okay, Your Honor. I guess I'll just conclude by saying this evidence was potentially impeachment evidence for the state's two main witnesses, which could have been used to undermine their credibility, which was already at issue by virtue of them being inmates, by virtue of one of them having asked for reduction in his federal sentence, and by virtue of late disclosures from at least one of them. So I think that it was a good faith argument that it could be potentially exculpatory to the defendant, and that the public interest in fair trials did justify the mistrial in this situation, such that the trial court did not abuse its discretion by deciding that a mistrial was appropriate. And therefore, the double jeopardy court did not err by denying the defendant's motion to dismiss. And the state just asked that this court, find no error and uphold the trial court's ruling on the motion. Thank you, Your Honors.
Thank you. I'm sorry, I muted myself. All right, Mr. Orsman, for your rebuttal. You got a little.
Sure, thank you. I don't have much time, so let me just go through as quickly as I can. The state doesn't do anything to address several of the cases I cite, mainly in my principal brief. The Cardines case, the Long case, it doesn't even really address Burkhead or the Schaefer case. They all held that evidence like this doesn't justify a mistrial. And corroborative evidence that doesn't have much value, it doesn't justify a mistrial. Doesn't warrant a manifest necessity. The State v. Smith case that I cite in footnote 5 in my principal brief, the DA is charged with knowledge of this evidence, right, for discovery purposes. She may not have known about it, but she's charged with knowing it. I cite Lane and McLean in my memo of additional authorities. They're DNA testing cases that say, look, the absence of evidence isn't exculpatory. It isn't, right? I mean, if the state is now like acknowledging that it's going to abandon that argument in all TCPNA cases from now on, that's fantastic. But I don't think that's really what the state is arguing, and I don't think this evidence in this case, I don't think there's a good faith argument that it's exculpatory. And even if it is, Mr. Graves can waive it, right? The United States Supreme Court in Ruiz specifically rejected the argument the state just made, right? The defendant doesn't have to know every in and out of the evidence of braiding material in order to waive receiving it. That's exactly what the Supreme Court held in Ruiz.
I have a question. Did the defendant's trial counsel not raise a motion in limine to challenge the evidence based on chain of custody? Did I not remember that from the record?
I'm sorry, can you say that again?
Did not the defendant's trial counsel actually file a motion in limine to prevent the evidence from being admitted based upon lack of chain of custody?
Yes, of the second trial.
Obviously, if it wasn't that important either way, what would be the basis for trying to keep it out?
Because the evidence had been tested and the state wanted to use it to corroborate the evidence. It may not have been extremely valuable. It may have only been corroborative, but corroborative value has, right, it's some value, but it's not sufficiently valuable to warrant a mistrial. Right? I'm not saying that the value is zero. It just isn't valuable enough to override his valued right to continue with the jury that was already impaneled. And I see that I'm over my time, so I just ask this court to reverse the second trial court's decision to deny the motion to dismiss. Thank you.
Further questions from the panel? Any further? Okay.
Question, thank you.
All right. Thank y'all both for your arguments.
Thank you.
Appreciate this, and we've got some interesting issues to look at. And I'm happy that all of our electronic things seem to work pretty well today. So very good. Thanks. And we will adjourn court virtually.
This session of the North Carolina Court of Appeals is now adjourned.
Donna, and are we going to remain online for the,
I think we join a new one we've got swearing in after this, and I believe we joined the new WebEx link for that.